Today, we will talk about easements in real estate. An easement is a concept in real estate in which one party gains the right to use another party's property in a defined way. An easement in gross is a personal easement attached to a single individual or entity rather than to the property itself. It is usually limited in scope and duration, and its terms, including payment, are negotiated between the property owner and the easement holder. It is often considered irrevocable for the life of the holder, but it is usually void if the owner sells the property. A typical property easement grants limited access to someone who is not the owner of a piece of real property. An easement in gross is an easement that is granted to an individual or entity that generally cannot transfer the associated rights to any other person. If the holder of an easement transfers their property to someone else, the current easement in gross may be considered void. The new property owner can attempt to reach a new easement in gross agreement, but there is no guarantee that the right will be granted. One familiar example of an easement in gross is a utility easement. These are legal agreements that allow utility companies to install and maintain infrastructure on private property. The party who benefits from an easement in gross does not have to own or reside in a neighboring property to be granted the associated rights. When dealing with easements in gross, the property owner often has the most say regarding the limitations stated in the easement. Easements in gross grant specific rights to someone other than the property owner, while an easement appurtenant grants rights to the owner of a nearby parcel of property. An easement appurtenant is said to run with the land, meaning that when the easement holder sells their property, the easement rights transfer to the new property owner. An easement can be terminated in 8 ways: abandonment, merger, end of necessity, demolition, recording act, condemnation, adverse possession, and release. Perhaps the simplest way to end an easement is to persuade the beneficiary to release or abandon their rights to the easement. A conservation easement limits the usage of private land in order to protect natural resources. Conservation easements are always easements in gross, in that they are not attached to a neighboring piece of land. The holder of an easement in gross is the person or entity that benefits from that easement. This type of easement generally cannot be transferred, although there are exceptions. The main difference is that an easement in gross is not attached to a specific piece of property, whereas an easement appurtenant continues in perpetuity when either parcel of land is sold. An easement is a real estate concept that allows one entity to use another entity's property in a stated way. An easement in gross is not attached to a property and is usually terminated if the owner sells their property, rather than encumbering the new owner. Here are 4 key takeaways. 1. An easement in gross is a type of easement that is attached to an individual or entity and usually cannot be transferred. 2. An easement in gross is different from an easement appurtenant, which is attached to a piece of property. 3. An easement in gross is often granted to utility companies, allowing them to install public infrastructure on private land. 4. If land is sold without disclosing its easements, the buyer can seek legal remedies for any lost value. Hope this would help. Thanks for watching.